we can just read the, I guess the ethics statement is right, the first thing.
Yep, I got it in front of me. I had to root around for it and lots of pieces of paper.
All right, we are good to go.
Okay. It is the duty of subcommittee members to avoid conflicts of interest and appearances of conflicts of interest in performing their duties as a member of the subcommittee of the North Carolina State Bar. Any member of the subcommittee who is aware of any personal conflicts or appearances thereof with respect to the matter before the subcommittee should disclose those at the meeting, either now or when you believe they are relevant. So Cameron, take it away, unless somebody has a conflict they wish to tell us about at this point.
All right. Well, it looks like, again, just for purposes of the live stream, our chair is unexpectedly unavailable. So Gina Morris is filling in for us as chair of the subcommittee. And Gina, it actually looks like the first thing on the agenda is just approval of the minutes from the last subcommittee meeting.
Right. Okay. Last subcommittee meeting was September 16th, 2021. Carmen emailed us the minutes a couple of days ago. So do I have a motion that they be approved or any discussion of needed changes?
Move approval.
Is there a second?
Second.
There we have it. Okay. Now Carmen, take it away.
All right. Well, as you saw from the materials that were emailed to you, Brian and I sat down and made some revisions to the amendments that were initially proposed for Rule 1.19. And what we did for your reference in the materials that were emailed out was put the new version side by side with the version we had at the end of the last meeting, so you can see what has changed in response to the committee discussion. And so our thought was we could just walk through the current version and along the way, hopefully explain, some of the choices we made in wording and what was included. So I think probably I should just start sharing my screen here. Let's see. Okay, can everybody see that?
Yes.
Okay. So this is the comparison, but I think it will be easier to see if we go down to a clean copy. So this is what we're working with now. The bolded parts are the amendments. So actually, I mean, this entire section, subsection B, was the initial amendment that was proposed to add a component to this rule that would prohibit sexually explicit communications with clients. We did add this piece to it in the last set of revisions. And I believe that was after we reviewed a couple of different statutory definitions of what is sexually explicit or obscene material, and we realized that we have seen some requests from lawyers to clients that were requesting nude images, but that weren't necessarily within the definition of what is sexually explicit. So that is I guess the first modification from what we were working with last time. So I'd be interested to see what the subcommittee members think about that potential adjustment.
Carmen, can you talk about what is the line between something that is relevant to the client's legal matter and something that is being asked for in another context? I'm not sure I understand your last comment that you've seen requests for something that was sexual in material but not nudity.
No, I'm sorry. It was the inverse. I have seen requests, for example, from a lawyer asking a client to send a nude photograph or say a topless photograph So that would involve nudity, but would not actually meet the traditional definitions of what is sexually explicit. Tasteful nudes, if you will.
Okay. Because I'm assuming that a personal injury lawyer asking for photographs of body damage or breast reconstruction or name it, but the issue being that that is relevant to the matter. Is there something else that would be relevant to the matter that would also be objectionable in some way?
No, I think that the final clause is designed to completely exempt from this rule any communication that actually is relevant to the representation. So your example was a good one. Certainly in domestic cases, there may be relevant evidence that is in fact explicit even. But if it is relevant to the legal matter, then this rule wouldn't have any application.
Okay. And you don't think there's any overlap between related to the representation, but somehow still objectionable?
Well, no, I'm not sure what you mean by objectionable. You mean actionable, like that?
Yeah. Against the
Okay.
rule, violates the rule.
Our intent in creating this was that there not be any overlap.
Okay. Got it. Thank you.
Any other thoughts about subparagraph B?
Just one last thought. There was a subcommittee that discussed, I guess, issues with, I guess, minors and stuff like that. And so we may want to consider adding just a little portion to B that says as long as it's in compliance with that rule as well. So there's not inconsistent rules. I guess you can't can't transmit photographs of minors and things of that nature.
Oh, so you're talking about like contraband, right? Like images that are illegal just to possess.
Right. And I think there's a rule on that, but I don't know what the rule number is.
Brian, do you?
Yeah, it's an ethics opinion. It's just the general notion that a lawyer cannot engage in something that's illegal,
right?
Just because it's related to the representation. And the contraband issue that's before the ethics committee right now is dealing with sexually explicit images of minors that mom finds on kid's tablet while kid is under dad's care, and she wants to send to her lawyer saying, look, dad's not supervising because our child is running amok on the iPad and sending pictures and all that kind of stuff. And there's that transmission of those images. The opinion, at least as it's currently formulated, is attempting to say that is illegal to possess, and the rules do not create an exemption where lawyer is now allowed to possess that information. So the rules can't override a statutory prohibition. So I don't know where that would. I mean, clearly, I feel like that's talking about something different. I don't know if there's a place that needs to be acknowledged here, or if there needs to be some other kind of clearly you cannot request anything or engage any type of illegal activity and actually put that into the rule. But I think that would probably be addressed under 8.4b already.
Right, and actually, technically, in the state of North Carolina, there is a statute that prohibits transmission of obscene material. So technically, what is described in this rule is also a criminal act. So we will keep that in mind if as we go through continuing to improve this, to see if that needs if we need to reference any of those acts that are also criminal. Thanks, Davis. Catherine, what say you?
When you're off mute, what say you?
When I'm off mute, what say I? So I was just looking at B, and it's listing these different means of communication, but it doesn't include just saying it. I mean, it seems to all be sort of related to some means of communication that's electronic in nature, but not just in person. But wouldn't we want to prohibit that same kind of communication in person?
That is an excellent point. Would it?
I thought maybe after the word means in the third line, you could just add communication through speech, comma, messages, images. Or something like that, just to.
Yeah, would it be means in person or electronic messages, images, audio, video? Is it that?
Yeah.
Like in person or
Yeah.
electronic?
So
So could it say communication in person or through electronic messages?
Yeah, I feel like we might want to kind of massage that language right there. You know, there's something that I think that's capturing what we're talking about. It's a really great point, Catherine. And whether or not that flows. Perfectly.
what if we just said statements? Would that cover comments?
Yeah.
Well, do we need to include gestures here?
Please, let's not. Okay, well, I think this track will allow us to, if we don't come up with the perfect language here today, that will allow us to remember that. I think you're right that the way it was written didn't seem to include just a face-to-face conversation.
Right.
And then I have one other thing, which is that says that shall not require or demand, but it doesn't say shall not request. And it seems inappropriate to me to ask for it, even if it's not in a requiring or demanding way.
Are you looking at paragraph C now?
Oh yeah, we're not on C yet, sorry.
Well, no, that's okay. It's just that C is require or demand is the language that currently exists in Rule 1.19, and it's the quid pro quo provision. So,
right. Well, that's why I was thinking maybe you could put in B, a lawyer shall not engage in or request, or put it in there somewhere so that it's clear you don't get to ask for it, even if you ask nice.
I actually like it. I think it might be applicable in C, request, require, or demand. I know there's the quid pro quo aspect, but I feel like I would not want a lawyer. I don't think a lawyer should put their client in the position of having to respond to a request for sexual relations as much as sexual communications.
Yeah, but both.
Yeah.
But those were my only two comments, and I think y'all are doing a great job here. Thank you.
thanks,
Yeah, Carmen, I see what you're saying about the quid pro quo, that I'm like, it may not be.
Oh, well, now I'm just not sure there's really a difference between requesting and demanding, but I guess.
Well, when it's in that quid pro quo context, I think you're right that it's the condition of that representation or incident too. Well, yeah, I don't know. I guess we'll have to. That's something else to consider. We'll have to kind of play that out.
And I think, Catherine, part of the reason that request was not included in paragraph B is because, again, we were tracking the same structure as exists in the current version of the rule, which is just a lawyer shall not have sexual relations with a client. We were trying to make a parallel declarative statement about the communications. So I guess in that sense, the way that we would, if we added the communications prohibition, the way that we would regulate requests to do this would be to characterize them as attempts to violate this rule.
Right, under what, 8.1?
8.4a.
8.4a, sorry, yeah.
And I'm not saying that's the right way. I think that we were just trying to have some internal consistency among the sections of the rule. Any other thoughts from the subcommittee about, I guess, subsections B and C at this point?
I guess my only point that Catherine hasn't made more eloquently yet is that I still think we run afoul of the boys can be boys exchanging of pictures and things. And I, don't think that's what we're intending to do here, but I think that if a lawyer who was representing a fraternity brother sent a nude picture of someone to the fraternity brother that was not related to the fraternity brother's representation, the lawyer would be violating B. And I don't think our intention is to grab that conduct here, because it's not sexual conduct but we haven't defined it to preclude that.
Well, Gina, I'm glad you bring that up. Brian and I we wrestled with that notion quite a bit when we were working on this. One thing I will say is that I think in the scenario you just described with the fraternity brothers, it is likely that any transmission of material during the representation would probably not violate the rule because of this language that we added. I'm just guessing if they were, had that kind of relationship. We basically, again, created a parallel to the existing language in the rule to say that if the lawyer and client, if the nature of their relationship included that kind of communication previously, then there's no expectation that it would change when they became lawyer and client. So there's that piece for people who had, just friendships, other relationships that predated the attorney-client relationship. More broadly on this topic of trying to create a carve-out that would exempt the kind of communication you just described, we really couldn't come up with any way to phrase it that didn't run into, I think, a lot of problematic concepts about, either heteronormativity or gender, or, I think literally just figuring out how to say what you're describing is very, very difficult. And the other problem that I had with it was more philosophical, in that right after we had this meeting, I became aware of some messages between almost exactly what you described in the last meeting. Was a straight male lawyer and a straight male client. And so I got to see what this actually looks like. Now, I'm not going to be showing them to you, even though I do love a good audiovisual presentation. But I'm going to give you the abbreviated summary that I think will give you some sense of how grossly unprofessional these communications were, but yet not actually violate YouTube's community standards, which we would if I showed you these messages. So this is the way I summarized it when I was writing a summary here. So lawyer proposed to one of his male clients that they should have a threesome with lawyer's employee, who at the time was married and had no interest in either of these men. Among other things, lawyer speculated that his employee might like to engage in double penetration with lawyer and the client, although she, quote, might need some liquor first. The lawyer also discussed his own sex life with the client, sharing graphic descriptions of his girlfriend's body and her orgasmic response. And then at the end of all of these messages, which again, I very much abbreviated and cleaned up, the lawyer says, "We should really get your case settled." And it was very, very jarring to read through this.
Yep.
and to see this is what we would be essentially putting the state bar stamp of approval on. And I think that the overwhelming majority of lawyers would not expect that, would not expect the state bar to endorse that conversation that took place. So that's sort of where we landed, in both in the challenge of drafting and then also in the concern about what would we really be creating an exception for, and what would that be saying?
So obviously that's disgusting and unfathomable. And I didn't know that anybody would talk like that. So I wasn't even contemplating that. But where I'm coming from is I'm trying to figure out what problem it is that we're trying to solve. And the problem that I believe we're trying to solve is lawyers in a position of power taking sexual advantage of clients. And so if that's the problem that we're trying to solve, I think we need to narrowly tailor our remedy to that problem. Now, what you just said, though, if we're contemplating that we would actually like to bar the communication that you just described to us, then I think that is a subject for a different rule. If the rule that we're talking about is a lawyer taking sexual advantage of the client. If that's not what we're talking about, then I need to sort of redirect my head and we think about broadening this thing. But do you understand? I'm being incredibly inarticulate about my dilemma right here. So do you understand what I'm saying?
I think I do. I guess the way I conceptualized it was the primary philosophical purpose of the rule is to prevent the kind of exploitation that you describe. If in accomplishing that goal, a rule also includes some additional behavior that may lack the exploitative component, but is by all measures unprofessional and likely to diminish the overall integrity of the profession, that's okay. I mean, I guess that was more the way I thought about this. And I could be wrong, for sure. That was my thought, is that yes, you've articulated the purpose well, but what would be the harm in also capturing this other behavior that is problematic for other reasons?
Well, the lawyers that could be prosecuted for violating this rule are not going to be thinking about it along the lines of the example that you just gave, unless we spell that out for them.
Oh, please, I don't think we should do that.
I mean, but I'm just saying, if we start prosecuting lawyers for that communication you just described to us alone, I don't think that they're going to fathom that runs afoul of the sex with clients rule 1.19 that we have expanded to include communication. I think, again, everybody thinks about this rule coming from a place of exploitation, and the client in your example is not being exploited by his lawyer.
I agree.
Well, I think this is just kind of two things that I'm thinking about here. One is the notion that consent to these types of activities during the course of the relationship is not really that's not a carve out, like just for the original rule. Just because client initiates a sexual relationship with lawyer does not mean that it's okay. And so, and I think that's where maybe we have to figure out, are these two different actions, the communications and the relations, are they on the same level? Do they have the same potential for harm, such that if the client initiates and clearly consents to it, we still say that's inappropriate? It's not okay for lawyer to engage in with client. And I guess that's where I come around to thinking that, as much as client, the scenario you're describing, client may start kind of going down that pathway with lawyer. They're just boys being boys, so to speak, which I will say I don't really endorse personally, but nevertheless, the just general notion, I understand what you're saying, that we don't want to have something that's overly broad, such that we have some sort of First Amendment challenge. But I do think that this might rise to the level of that type of conduct that we're saying, consent or not, it's just not appropriate for a lawyer to engage in, because there may be an exploitive nature. There may be some sort of I guess kind of that, whether you talk about, do the communications tend to lead to potentially more inappropriate behavior, even if you're dealing with, I guess, I don't know if you want to do the slippery slope thing of like the description that Carmen just gave about two straight men who are engaging in this type of conduct, this type of communication, what preceded that to the point that they felt comfortable actually engaging in that conversation. But the other thing and I don't think this is really a justification. I don't think it can serve as the justification for the rule, but I think it's more of the reality, or maybe the practical consideration. And that is, if that type of conversation is occurring and it's consensual between, two individuals, I don't know that it's getting reported. That's not to say that, you can generate a rule that's otherwise not appropriate as long as people aren't reporting it. But I think there is kind of a bit of a practical consideration in my mind that I don't know that they're going and telling on each other for engaging in that type of conduct. So I don't know how big of an issue it really would be, I guess is what I'm trying to say. So that's for whatever it's worth.
Arlen, just a curiosity question. How the case that you described, where there's that long, explicit sexual content, and it ends with, "We need to settle your case." How did that come to the bar's attention? Was it the client?
No, the client provided the messages to the employee who they were discussing. I guess at some time after this exchange of messages, they actually developed a friendship of some kind, and the client said, look at the way your boss talks about you, basically. So we received them from the former employee, not the client.
Okay, that at least makes sense, because I was trying to figure out how did we get a plaintiff in that case, but that makes sense.
Any other thought? I mean, I do think this question of whether and how any certain versions of explicit communications should be exempted is important. So I'm curious if any of the other subcommittee members have thoughts about that.
Well, I'll just say that I don't personally think that there should be like a boys will be boys exemption. I think that the language that's there now in paragraph 3, I mean, for me, I think that's sufficient. Because if you want to always try to think of a way around or a loophole, somebody's going to always do that. But I think that this covers situations where people are friends or have some kind of relationship and are used to talking to one another like that. And, that keeps them safe. But also, why would you I don't know, want to kind of create. Nothing in my practice has ever made me want to say, hey, let me, befriend this person and let's just start sending these crazy messages to one another. So, I mean, I don't think there needs to be any other language. That's just my opinion. I think that this covers this. And if that's the kind of relationship you had with somebody prior, then I think you would be fine and you wouldn't have to worry about being prosecuted just with that language right there.
All right, well, it sounds like this is something we're probably going to continue to talk about. For now, hearing no additional comments, I think we can look at the scope section, which, as you saw from the side by side, we did end up just rearranging things. We were really trying to streamline this so it was more clear. And the existing rule does have some scope limitations on it, and so we decided just to build on those. To specify first that the rule applies to current clients, and then some other descriptors, some other categories that we discussed in the last meeting. The first of those, it was a limitation, or not really limitation, a specification that the prohibitions on this sexual conduct would apply to managerial employees or other agents of a current client. I think the initial suggestion was that it would apply to agents. The term managerial employees is used when we talk about organizational clients a lot. So this was what Brian and I came up with to try to address that request from the subcommittee. Looking at it again this morning, I think it probably needs some workshopping. I can see how the managerial employee provision would be relevant for organizational clients, although as Mac pointed out last time, this rule is not frequently seen as applied to a lawyer's relationship with an organizational client. But
although just as an aside, we did field an ethics call along those lines.
Oh, that's right.
In between our last meeting and this, where somebody called and asked, basically, on this position in a corporate, or I'm this position or advising a corporation, there's this individual that I've started a relationship with who was employed by the organization. Am I going to be violating Rule 1.19 in that situation? And in that situation, I will tell you that the person that they were referring to was not a managerial employee, did not direct the representation, and so I could not say that there was a rule that prohibited it, but certainly said I'm glad you called and that you're thinking about that. If there's any sort of intersection between that person's professional duties and whatever you're doing in your representation, there needs to be a kind of a pump in the brakes, so to speak. But nevertheless, we did have it. It's a relevant thing. So I think that's I think the managerial employees, like Carmen said, is an appropriate distinction. It's something that's already in the rules, and the other agents really was kind of referring to what Dorothy had referenced with regards to representing juveniles or anything like that. When you've got a lawyer that's making comments towards mom, while they're representing the son or something like that. So that's kind of where that came from.
Right. I mean, assuming that parents are going to be treated as agents of their, I don't,
yes.
That's what I'm saying. That may not be exactly the right word. Although I did note that, for example, if you were preparing like a will for an elderly client, and that person's power of attorney was somehow involved in that representation, which is often the case, sometimes problematically, that would be a good example of a client's agent who it would not be appropriate to have a sexual relationship with. So I think there's something that we could do here, but it's difficult to select the right word. So we put subparagraph B in there to indicate that that's something we wanted to look at, but would welcome any thoughts on how to include this, whether to include this, and what words would really capture what we're trying to do.
I like it. I think it should be included. I'm wondering, since agents has an actual technical definition, if something like representatives might be broader to capture what you just referenced.
I think it would, if we're talking about individual clients, I think that representatives would capture more. But then I'm concerned if you're talking about an organizational client, does that then, what does representative mean in that context? Does that expand it? So it might be that we actually need to just make this into two different categories, one for organizational and one for individual.
This, by the way, would be why I'm allergic to the ethics debates.
But you're so good at them, Mac.
Okay. Can't see what I'm typing.
Are you headed towards saying representatives or agents? Or are you looking really at making a whole new rule?
You mean it? I am not really headed anywhere right now. What is your suggestion about? So just say, man.
If you said representatives or agents, that way, if it's an organization, we'd focus on agent, and if it's a juvenile client, we would focus on representative.
Okay.
And please don't ever tell anybody that I contributed to this.
Sounds like footnotes.
Need to maintain my allegiance to grievance and my just my scorn of ethics.
Okay, so I think that is improved. Any other thoughts about B? All right, well then, so this C under the scope section, or 1C, I guess, is this is new, and this is something that occurred to me because what happens when you try to apply the rules of professional conduct to various facts over decades is that you realize where the loopholes are, where the probably unintended uncovered areas are. Pardon that phrase, given this subject matter. I just can't help it. And that is that there is this window of time during which a member of the public has a certain level of vulnerability vis-a-vis a lawyer, and that's when they go in for a consultation and disclose often confidential information to a lawyer before they've decided to actually form a lawyer-client representation. And so in my mind, that person has really the same level of vulnerability by virtue of being in sort of a power imbalance with the lawyer, and therefore that is a situation where we might want this principle to also apply. And we have to, I think we have to tailor it to specify just because a person may come in and have a consultation and then not become a client, that person isn't, protected by this rule, for lack of a better way to phrase it, indefinitely. It's only in that window of time where the client may have made these disclosures of confidences, but hasn't yet become a client. And that is an instance where a lawyer could try to engage in some of the behavior that is prohibited by the rule with respect to current clients. So what are the subcommittee's thoughts on that?
Gina, can I ask you a question about that?
Do I?
No, I'm about to ask you a question about the real world. And that is there a moment when somebody comes in and talks to you about a potential representation and you don't hear from them again? Is there a moment that fits this description of determined that no attorney-client relationship ensues?
So maybe domestic lawyers completely disagree about that, and the gray area between in domestic law between current client and prospective client is crazy and leads to so many problems. And this is not relevant for our discussion, but because it is a nuanced situation, I'm going to give you an example. Mm-hmm. If I represent wife who has been a victim of domestic violence and husband calls my office to try to retain me to represent himself in connection with the circumstance, when he calls and speaks with my secretary about whether or not I can represent him, he is a prospective client for the purpose of that conversation with my secretary. My secretary then says to the prospective client, "We cannot represent you, sir. We have a conflict." The prospective client now knows that I probably represent his wife that he beats up regularly. But guess what? I'm not allowed to tell her that he called. And so we are putting a current client in jeopardy because of duties to a prospective client. So that is an issue that needs to be resolved by the state bar eventually. It's not yet, but my point is, in the context of family law, the world of prospective clients is huge and scary and, kind of a nightmare. And so we do treat them in many respects with the same duties that we give to current clients. And
you answered my question, which is this is messier than it might appear to be.
Exactly.
I wonder if it would work to say until it is communicated to the client that no attorney-client relationship will ensue. In other words, we just place the burden on the attorney who wishes to engage in this behavior to clarify, I'm definitely not your lawyer, before engaging in this behavior. Does that make sense?
Yes.
Yeah,
me too.
Yeah.
Well, that'd be a weird conversation, wouldn't it?
I won't take your case, but would you like to go to dinner?
Exactly. Right. Well, that's not quite right either, but
communicates. Yeah. And Brian, when you get ready to put together the subcommittee to fix Gina's problem, I'm unavailable. Thank you.
I was going to say, you're number one. You're volunteering.
He's the chair.
okay. yeah, that might be slightly improved if we really study it too, but okay, but do you all think that is better?
Yes.
Okay.
Mhm.
All right, and then this is paragraph 2 here under scope is just what already exists in the rule, exempting pre-existing sexual relationships. And what we did was add a parallel paragraph here that makes the same exemption for lawyers and clients who all, previously sent each other sexual communications before the representation. We thought that would make it easier to understand and also makes logical sense. And that brings us to the end of the edits that we've made since the last meeting. I think the notes that we have here are going to help with the next round.
Carmen,
Yes.
is there any conflict between D1C and the one below it, 2? All right, so under 2, it doesn't apply if there's a consensual sexual relationship between the lawyer and the client before the representation commenced. But when the person you had that relationship with comes in and says, hey, I enjoy our relationship, but now I need a lawyer, are they now a prospective client and the rule does apply?
I see what you're saying.
I'm not saying, I'm asking.
Well, I think your question helps me see that, yes, there could be some conflict between those two. Well, I think even more simply, if someone propositioned a prospective client or had started a sexual relationship with a prospective client before they agreed to take on the case, it would appear that paragraph 2 takes that out of the realm of regulation. Is that what you're saying?
I think it's that gray area between we have a relationship, but then I ask you to be my lawyer. And so for a minute and a half, I'm a prospective client before we're all covered by subparagraph 2 that says, if you had a relationship before, it doesn't matter. Are we clear that the prospective client rule doesn't somehow trump the previous relationship rule?
Got it. What about this? I'm wondering if what we'd want to do is change. No, because then we'd have to change both of these paragraphs to say something like.
Well, why don't you and Brian kick that around and see if you think that actually is an issue?
That's exactly what I'm thinking. Yeah, but I think it is.
Yeah.
Don't waste any brain power fixing it until you've decided it really is an issue.
Right.
I think I'm glad you pointed that out, because I think it is an issue. It doesn't need to be a big issue, but we're going to have to think about phrasing.
And I have to say that for all the comments that Mac makes about not liking the eggheadiness of the ethics committee,
He sure is an egghead. This is like that egghead banter that Carmen used to engage in with Lane Williamson.
Right.
But I do have a little bit of a concern about Underscope, paragraphs 2 and 3, because it casts it in terms of whether such a relationship or such behavior was consensually engaged in before the representation commenced. And that seems to me like it's potentially in conflict with D1C, because that indicates that it's covering the relationship before the legal representation commenced.
That's right. That's right. And I think that was what Mac's question brought up also.
Well, so let's say you have a prospective client in your office and you start, exchanging sexual communications. And so that happened before the legal representation commenced.
Right.
So this would indicate that would not be covered, and they could do it in perpetuity because it was happening before the legal representation commenced. So
right.
I think you can't define the relationship as the legal representation in one place and define it as something broader than that in another place.
Right. I agree. And I think that's what we need to resolve. We agree. It's a little bit difficult to do on the fly, I think, because
Sure.
It involves a couple of different sections with similar language.
Well, if that's what Mac was saying, I apologize that I don't have like good egghead cred, and I wasn't necessarily understanding that what I was thinking was what was being discussed. So I just wanted to make it clear.
I agree. Catherine does not speak fluent nerd like some of us.
I don't speak fluent anything, so.
I think we can work that out, though. You're right. I mean, I think it's what this shows is that when you start with kind of stock language, you start with an existing rule, and then you try to add a new concept to it. You then sometimes have to work around the existing language. But if we're in here making amendments, we can always amend the existing language too, if that makes the whole thing work as a whole. So we will do that. Are there any other, I can get out of this screen share, but are there any other ideas or concerns of the subcommittee just about what we're doing here? Suggestions, anything?
I've never been a prosecutor, so I don't know how this looks when you're trying to figure out how to charge it and what the elements of proof are. But for those of you who have done that work, and that's at least 3 of you, do you have any concerns that this is either too vague or that there is no evidence of it, or any other issue that we could address to make this more effective in real life?
Well, I can answer for sure that it is a real issue.
Yeah.
It is a real thing that is happening with some alarming frequency. And it just seems like something that should be unequivocally and rejected by the state bar, in my opinion. There's just, lawyers have plenty of other people they can do this kind of thing with. It doesn't need to be their clients. It's just, as to vagueness, we don't want this to be vague, particularly because it doesn't really have a state of mind component. I mean, it's just, if you do this, it's not acceptable. And so I think the conduct needs to be very specifically defined. I think what we have so far is at least as clear as a lot of existing statutes and regulations. The only question would be whether we would go into as gruesome detail as some of those other sources in defining what we mean by sexually explicit. And we included in the email materials a federal and a state statute that we looked at when we were looking for definitions. I don't know. Personally, I would prefer not to include all of this type of language in our lawyer's handbook. It just seems a little bit graphic. I suppose it could be cross-referenced to a statute without using all the word, restating all the words. But that, I think so far we've done fairly well at defining the conduct.
Yeah, and I'll add that, because my mind drifts back and forth between my old job of prosecuting and my new job of advising people. And I feel like if I got a call from somebody asking, which, by the way, doesn't really happen. People don't say, "Hey, I'm thinking of having sex with my client. What do you think?" But that said, with this, it did happen once, but nevertheless, if I had this rule to advise someone on, I feel like it's pretty clear. I do like the, and I think that was a part of the kind of rule drafting session that Carmen and I had to address, Gina, your concern, which I think is like it's a legitimate concern for kind of the practical reality of this rule and the impact that it has on the profession. And I think that's where we came up with we need to have that statement that if there's a pre-existing kind of relationship between client and lawyer, that would be something where we're not trying to touch that, but it's really just we're talking about, we're addressing the new relationship between client and lawyer, and whether or not you can engage in that type of conduct, does that run afoul of the rules? I feel like this is as clear, if not more clear, than a number of our rules. And so I feel confident about its integrity in that regard. I don't think it's overly vague to run afoul of any sort of First Amendment concerns or anything of that nature. I feel fairly good about this, but I think some of the conversation today has pointed out where there are some of those, I guess, those areas for improvement. And I think the next draft will be that much better.
It just strikes me that in areas of the law like domestic work, criminal, immigration, where there really is a power differential, that there might be some real world circumstances that those of us who live in a relatively innocent world don't ever see and couldn't anticipate. But it's been really helpful having Gina's comments, because she does see a piece of that world and we'll know what that is. Y'all are prosecutors. You've seen either that in the state bar work or in a previous life as literally a prosecutor. I just want to make sure that we're covering what we need to cover, not leaving it vague, but not missing something big that we don't know about because we don't practice immigration law.
Yeah, and you're right, Mac. I mean, the cases, all the cases that I can think of where the existing Rule 1.19 was implicated were either domestic or immigration cases. I mean, that's not a coincidence. I mean, the level of vulnerability is very high, and the subject matter, of course, in domestic cases is there's just a lot more personal disclosure in those cases, I think. So, all right. Well, I think Dorothy will be proud of us for making some headway, tracking some changes, getting some direction for how we want to keep improving this for the next meeting. But we can report to the Ethics Committee that we are making progress. Right, Brian?
I think it's great, and I'll look to Mac to provide that report in January.
Brian and Carmen. Brian and Carmen.
Yes, Catherine.
Can y'all stay on for a second? Let me just share a couple of thoughts I have before they fly out of my senile brain.
Yes, of course.
All right. Well, all right. I think Gina, Gina, can you tell us we're adjourned?
Oh, yes, we are adjourned.
Thank you.
Thank you, Gina.
Thanks, everybody.